thank you all for coming out tonight. As you know, you're in for a treat if you've been to one of these sessions before. I always go home with my head buzzing with all the new information that I've had and the thinking that I have to do about it, which is always what happens when you come to the library, right? Mm-hmm. So I want to thank Meg Mott, of course, for coming to present this evening, but also thank you to the Friends of Brooks Memorial Library, without whom this program would not be possible, because they provide the funds. They raise the funds and provide the funds for our programming. So many of you in the audience I know are our friends, and I invite all of you to join the great cohort of people that are the Friends of the Library. And with that, let's listen to Meg Mott.
Thank you. Thank you, Star. Hi, everybody. Thanks for coming out on this anniversary of 9/11. And I will make a little reference to it again at the end, but I think it's important for us to be talking about our civil liberties, particularly since the attacks of 9/11, because not that the civil liberties have not been eroded in the past, but certainly we're in a condition where they tend to go away. I put out on the publicity that the Fifth Amendment was a very inconvenient right. There's another way to think about the Fifth Amendment, and that it's also a costly right. So it is a big cost to engage in rights for the accused. So that'll be something that I'll be pressing on a little bit about as we go down this story about the Fifth Amendment and how it started. And periodically I may say something like, is it worth the cost in this case? Are we still willing to defend what the Fifth Amendment gives us? Because it's one of the rights, not maybe as much as the Sixth Amendment. It's kind of amazing when we talk about that next month, about juries, how little juries are getting used anymore. So we are willing to cede certain rights, but the rights of the accused are usually the first to go. So let's get started. The Fifth Amendment, what does it mean? Also, a very sad announcement. We have no singers tonight. I know, how sad, right? Usually we start this and I say, are we going to read the Fifth Amendment or the Fourth Amendment? And no, it's Brattleboro. We're going to sing the Fourth Amendment. And then the Fourth Amendment people get up and they sing, and it's also glorious. And I'm so sad to say that we don't have any singers tonight. Maybe the upside is this is one of the longest amendments in the Bill of Rights, so we could be here a long time singing and never actually get to a discussion. But the other piece is that it's the semester has started. It's harder for Neely Bruce to come up. So anyway, for those of you who only came for the singing, I will not be offended if you now rise and decide to leave. But if you want to hang in there for the actual discussion, let's get started. So the Fifth Amendment, what does it mean? I'm going to put the whole text on the screen in just a second. But something that we've been talking about in Brattleboro here is this is law. This is a certain kind of law, Constitution. And who decides what this means? Anybody have any ideas? Like, who decides what this...
Bankers.
The what?
The bankers.
The bankers. Okay, there we go. The bankers decide what this means. Yeah? You could say that. That's a cynical answer, but okay. Yeah. Jinsey says the courts, and especially that's really the big one. There you have your little gavel. The law is interpreted. It's not codified. And we had some conversations here. Daniel and Gemma were asking questions about, well, what do you mean common law? And Gemma said, well, common law is actually very specific. It's not like statutes. Absolutely right. It's interpreted. And who interprets it? Usually the judges. However, now, who said bankers? Bankers. Is that you in the back? Who said bankers? Oh, okay, great. Bankers. Okay, thank you. I'm so glad we have a peanut gallery. So you could say the bankers are affected, are able to affect these decisions, because it's not just the judges. The principles they use in order to try and figure out what these laws actually mean are settled by practices and by institutions. And some of the practices have to do with money. And some of the institutions are influenced by money. So yeah, that's going to have a factor to it. But there's another, besides just the bankers and the judges. When we get into practices and institutions, what did you say?
The people.
The people, thank you very much. Interpretations are shaped by public expectations. And so we may not even know we're interpreting the law, but we may start acting as if we've interpreted the law in a certain way. So our whole mindset, our whole disposition has a lot to do with how these laws get interpreted. And that's what we're going to play with a little bit today. Before we begin with the text, public expectations right now about democracy, the Constitution. We have a constitutional democracy, Republican form of government. Anybody have a sense of what are public expectations about all of this right now? Going down the tubes, absolutely, yeah. So here's some, oh, sorry, I jumped ahead. I forgot I should look at over here to find out. In fact, maybe I will just keep jumping ahead and then I'm going to go back to this. Here's some current public expectations. Some 23% of American millennials say that democracy is a bad way or a very bad way to run a country, which is a little different. Can you remind me your name? Carol. So Carol said it's going down the tubes. Carol, I'm going to guess you're not a millennial. So, but amongst younger people, the very idea of democracy is a bad way to run a government. Among 1,400 young adults asked about the importance of democracy, only 39% said absolutely important. So that's, and where did I get this? Something called from purplefordemocracy.org, which I found out from my brother-in-law, John Foxe, which is trying to work on building democracy. And purple being important, right? Not blue, not red. Bring them together. So all these statistics come from that website, purplefordemocracy.org. But this is the one that really, this is not just millennials. People always like to say, the young people today, they don't understand about democracy. They're not interested in democracy. But this is more than 29% of the public recently expressed support for either a strong leader or army rule. That's a big number. That means that there's a disposition for authoritarianism. And that's not just happening in the United States. That's happening across the globe. 29% is a pretty big number. And when we're thinking about authoritarianism, the opposite, I think, is a disposition for democracy, which means it's going to be messy, and we're going to have these rights, and things will get a little bit more complicated. So I'm going to go backwards now, because we also spoke about when we're reading these texts, yes, the judges are trying to figure it out. There's a couple of techniques to do it. And one is, what are the words, the actual text? But then the words, when we start looking at these words, what does it mean, compelled to be a witness against oneself? What do those words mean? So then we're going to go to historical context. But even understanding what they were thinking at the time may not help us understand what these words mean. So that's when we go to ta-da-ta-da, political theory. Why am I so excited? What? Somebody's going to say it. What? Because I'm a political theorist, and there's many other political theorists sitting amongst us, political philosophers. And so we have this moment of pride. Oh, here's our time when we actually get to say something, and people might be interested because we're going to talk about those principles, those big principles. So when the judges get lost, who do they come to? People like me, right? Casey is another political philosopher. And then we have some budding political theorists from Marlboro College sitting here. These are who the judges need. So I make a big deal of that one. Consequences. The other way they interpret is, what is going to be the effect of a certain interpretation of this amendment? What will be the consequences of it? Stare decisis, anybody know what that means?
To stand by things decided.
Standing, this is Eric saying, a budding political theorist, who is standing by things that were already decided. Let the decision stand. So whenever the courts decide something, woohoo, now we have something that's substantive, and that can help us interpret what these words mean. But this is the one that John Marshall didn't use. John Marshall being one of the first Supreme Court justices to figure out, whoa, if you're a judge, you can actually do a lot through interpretation. And that is public expectations. Judges tend to diminish the importance of public expectations unless it's a famous type case like pornography. You know it when you see it, in which case you look to community standards. But one of my arguments is public expectations have a lot to do with how we understand all of this. So if public expectations are democracy isn't worth much, then these rights aren't going to be worth much. And if public expectations are put the bad guys away, then this next right that we talk about, the Fifth Amendment, is not going to be worth very much. So, would somebody be willing to read the Fifth Amendment? I know I won't ask you to sing because you won't have a backup band and there won't be a conductor, but would somebody be willing to sing this, or to state the Fifth Amendment? Eric? Okay. Oh, we'll give it to Eric and then we'll pass it back to Charlie for some of the others. Thank you. Yeah, I'll let you go. But you read everything on here and then I'll tell you when you can pass it back. Is that all right? This is what political theorists, we tell people when they need to share.
Okay. All right. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger.
Any confusion about any of these words? Does it seem like, yeah, Gemma.
Or otherwise infamous crime.
Yes, so what do you think that means, Gemma?
I haven't the slightest idea. I know that it's generally interpreted as meaning a felonious crime.
Oh.
And felonies have a specific historical context as to what constitutes a felony. But that's not what it says.
Right, so there's a little vague thing with otherwise infamous crime.
And this is my favorite kind of phrase in the Constitution as an originalist, because we don't know necessarily what or otherwise infamous crime would have meant to the people of 1789 or 91.
Right, exactly. Kevin, is that your name? Robert, sorry.
But don't those words also reflect the time that the founders were debating these issues?
Right. So, we would want to do a little bit more historical research in order to answer, absolutely, Robert, what that means by infamous crime. But it is a somewhat vague term, right? It could be kidnapping, and we could have all sorts of ideas. Yeah, Eric.
I guess I see,
you have to use the mic.
I guess I see it kind of focused on like capital crime. Like I think, when we think of capital crimes, I think it's a very specific set of offenses, a set of things that people sort of end up being put to death for. And so I think otherwise infamous sort of hinges on just the definition of what a capital crime is.
And Eric just tells us that a capital crime is one in which the death penalty would emerge, right? But a big piece for just this first part is to notice that you do have certain protections. There has to be either a presentment, public notice of what the charge is, or an indictment, that it went in front of a grand jury, an indictment came down, unless, of course, you are in the military, in which case, sorry, you don't have those kind of protections. I'm going to move through a couple others. Eric, do you want to read this one?
Sure. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb.
And speaking of capital crimes, of life, we're starting to see how in this Fifth Amendment, where there's lots of protections these are all going to be protections for the accused, of life means that capital punishment is pretty much baked into this amendment. Any questions about this part? Double jeopardy, like you can't charge someone twice. Let's move back to Charlie.
Nor shall be compelled in any criminal case to be a witness against himself.
Yeah, what does this one mean? Taking a Fifth Amendment, says Carol, right? Taking a Fifth Amendment, like taking the Fifth. So this one, maybe we have a sense that we understand pretty well because you get to plead the Fifth. Yeah, I may press on this one a little bit more as we keep going. Charlie, you want to read the next one?
Nor be deprived of life, liberty, or property without due process of law.
Do these words all make sense? Everybody's nodding? Gemma's laughing? Gemma, why are you laughing?
What is due process of law?
Thank you. What is due process of law? Do we know? I'm going to write down. Just to, since everybody here said, oh, yeah, this is cool, I know due process. So what do you think it is? And we'll just see how that tests out.
It has to be in a court.
It has to be in a court, says Jinsey. Yeah? Anything else?
There has to be a neutral arbitrator.
Neutral arbitrator, yes? Anything else?
There have to be some laws.
There have to be some laws. And can you remind us your name?
Walter.
Walter. Yeah, there have to be some laws. Anything else? Daniel.
It has to result in a victory for the people with the most power, money, and guns.
I'm going to just call that Daniel's answer. Yeah, okay. What Daniel said, it has to end in victory for people with guns, money, and power and influence. So and Gemma, is that what you want to say too, Gemma?
No, I was going to say, there must be...
Can you give Gemma the mic?
There must be an appeals process.
There must be an appeals process. Okay, nice. Yeah. And we could also probably say that you shouldn't be in double jeopardy, that there should be a presentment or an indictment if you're charged. So some of these things that we're talking about are also baked in the Fifth Amendment, and there's just one other little spot. Charlie, do you want to read that?
Nor shall private property be taken for public use without just compensation.
Which is known as the takings clause, which means eminent domain. And we could spend a whole evening on this one, which would be way fun, especially if you're from New London, but we're not going to be able to do that tonight. New London, there was a famous case in which property was taken, and it was supposed to be for public use, but it was a development corporation, part of the city. It was tied to the city, but anyway, people had their property taken and it wasn't for public use. But anyway, Justice Souter is living with that. Okay. So we're going to really, at the first part, we're going to focus on this one. No person shall be compelled in any criminal case to be a witness against himself. And just as Carol was saying, usually people say, it means this. You take the Fifth. You don't want to say. But look at the language. Does it really say, shh? Does it say this? It says, shall be compelled. So there's an element here that's not just about keeping quiet. It's about being compelled. Who do you think is compelling? The state, prosecution, exactly, yeah. So at the time, so now we're going to do what Robert says. In order to try and understand what were they thinking at that time, why were they so worried about being compelled, the big bugaboo on the horizon for this whole thing was something called the Star Chamber. It was something in England. It was a court. I'm going to put court like this, because the way it worked for the Star Chamber is, let's say you were a king of England and there was somebody, and you were at this particular moment, you were a certain kind of Protestant, and there were these Puritans out there and they did not abide by your understanding of God. So what you just did is like, you need to come with me. I don't tell Jinsey anything. You just come with me. We go to this room, and in this room, I say, you have to take an oath of office, Jinsey, because I can see in your eyes, you're not really of the same faith as I am. And then I start asking all these questions, and Jinsey must tell the truth. If Jinsey doesn't tell the truth, it doesn't go well. We'll see a picture. Yes, Robert has a hand up, and then there was a hand back there.
See, what's the word? Is that person defended, or does he have a like representative?
Oh, let's see. In the Star Chamber, first of all, they met in secret, so nobody even knows about this. You're just taken in. There's no indictments. There's no charge. There's no witnesses called, and there's no records.
We don't like the way you worship your God.
We don't like the way you worship your God, and ergo, you are coming to the Star Chamber, and this was how a lot of justice took place in England. You had your hand up. Can you tell us your name? Kevin.
It wasn't just for the wrong kind of Protestants. It was for Catholics and really anyone
Who did not fit.
anyone who was politically inconvenient.
Anyone who was, Kevin says, anyone who was politically inconvenient. Exactly right. So there's like that lock on the door. Take that person. Jinsey, who's feeling very nervous around me, can you give, Hannah, can you give Jinsey the mic? We got to find out.
Okay. This was just something that we had an Episcopal priest who had been a Catholic priest, and he said this, that he said, worship is about God, religion is about power.
Uh-huh. And that might be a nice defense against just these kind of tactics that are being used. So what happened, you may not be surprised. Hannah, do you mind taking some? Thanks. This is what happens. This is Matthew Foxe's book of Martyrs, 1563. Different groups, as Kevin says, it's not just Puritans. This was created by the Puritans to sort of pass the stories of their martyrdom, but it happened to Catholics under Protestants, depending on who was in charge. I mean, it's fairly grisly. You can see why there's that ship there. Let's get the blankety blank out of this country. We are heading to New England. And in this book, which was widely published, widely disseminated, the people began to tell stories about what they were going through and why it was wrong. Who was it who said, it was just said, somebody just said here, this is not justice. This is taking away people who are not expedient for the king. So what could they say in their honor? I know, it was what Jinsey just said. They came up with a defense, and it wasn't what is between me and my God is different than religion, which is all about power, although that will become a response to this sort of thing. What they said is, nemo tenetur sipsum perdere. Everybody knows that one. Nemo tenetur sipsum perdere. Do we have any Latin people in here? Or Latinus? Yes, great.
That's literally the sentence that we just talked about, right? Nobody shall be compelled to sort of put himself forward in a way that suggests to be of disadvantage to him.
Exactly. And can you tell us your name?
Henna, sorry.
Henna?
Yeah, I mean, you've done in Marlboro.
Okay. Oh, great. Thank you, Henna. And am I saying your name correctly? Henna, we're going to give you the mic so that Jinsey can hear that, because that was just so beautiful what you said.
Sorry. So nemo tenetur means nobody shall be held, and then prodere is to sort of give himself up, in a sense, and se ipsum is for himself. So nobody shall be compelled to give himself up.
Yeah.
That's really the idea of that Fifth Amendment clause.
Exactly. And now we're seeing that compelled in there. Why is that word so important? Because nobody should be compelled to be a witness against himself. No one is required to bear witness against himself. Sir Edward Coke, who's a legal theorist, is operating a little bit later than Matthew Foxe. And he does that amazing thing. The Puritans have come up with this defense. They're saying it amongst each other. They've put it out in this book with really grisly illustrations. And they're telling each other, this is the defense you want to use. You get taken to the Star Chamber, you say, nemo tenetur sipsum perdere. That's what we're all going to say. And then Sir Edward Coke, who's a legal theorist, writes it in a book. And all of a sudden it goes through a little, I'm tempted to say, transubstantiation. It's moving up the chain of being. It went from the Puritans talking to each other, saying, nemo tenetur sipsum perdere, and then it gets put in this book. And every single lawyer in the Queen's Land, which includes American colonists, are reading this book. And they begin to understand, wait a minute, this is part of the big puzzle. This is a key right. This is fundamental. This is inalienable. We're starting to get into Jeffersonian language. But so it starts as Puritans sharing information about how they went, what the misery they went through in the Star Chamber, and then it starts to take on this. And once Sir Edward Coke puts that in his book, it becomes common law. It's not written in the Constitution. It's not in a statute. It's this wild thing that the Anglo-Americans have. It's almost with us on paper, but not quite. So it means no one is required to bear witness. Yeah, and I should have probably used the word compelled. This was the translation I was using, but so we begin to see why compelled is in the Fifth Amendment. Okay, so this sort of gives us some of the historical context. But now let's press a little bit about why is it so terrible to compel someone to be a witness against himself? Especially if we don't have a Star Chamber anymore. Because we don't have a Star Chamber, we started this whole new thing. You're going to have an indictment, you're going to have witnesses, you're going to have an attorney, you're going to have a court, there will be a record, there will be a right to appeal. So we have all of this apparatus now in the United States. And still this Fifth Amendment is going to be important to us. Because here's a case from Vermont. 1819, the murder of Russell Colvin. Russell Colvin, this is an artist's depiction of the murder scene. These are two brothers, neighbors Jesse and Stephen Bourne. They're Russell Colvin's neighbor, and they're also their sister is married to Russell Colvin. So everybody assumes when Russell Colvin disappears, it must be the brothers. Because Russell Colvin is a ne'er-do-well, he's always at the pub, he doesn't take care of his sister, they've all said bad things about him, and so for a long time, everybody just assumes the brothers have done it. But then an uncle starts to have dreams in which he's visited by Russell Colvin, who says, you have to do something, because my murder has not been avenged. The brothers, this takes many, many years. So then the brothers are tried, they're convicted, and they're sentenced to hang. The brothers the entire time say, we're innocent, we're innocent, we're innocent, we're innocent. We didn't do this, it's a big mistake. You guys don't understand. We don't know where he is. He's not dead. We didn't kill him. There's no body. But he's sentenced to hang. So here, they confess. Right before they're about to be hung, they confess. Why would they confess? They didn't do it. What is it about? The human species. They had a good trial. They were convicted. They said they didn't do it. Then they confess.
They haven't tried it yet?
They what?
They haven't tried it yet and might have gotten them out?
They hadn't tried, so Charlie is saying that they hadn't tried that tactic. And maybe if they confess, they wouldn't get hung. So there's always that hope. Nah, didn't work. Anybody else know, why would somebody confess? Especially at that time, 19th century, it's a religious community. A religious belief, yes, so that if you're about to die, maybe you didn't kill him, but maybe you meant to kill him. Maybe you really wanted to kill him. He was a blackguard, and your sister was so unhappy with him. And so if you were going to die, even though you hadn't killed him, you would confess to doing it for religious reasons. Yeah, Robert.
It's called the deathbed confession.
The deathbed confession, whether or not they did it or not. Because here's the deal. Russell Colvin was alive and living in New Jersey. And because this case went into the newspapers, somebody said, wait a minute, I know this guy. He's in New Jersey. So anyway, long story short, they were able to trick Russell Colvin to take a stagecoach to pass through Manchester, New Hampshire, right before the hangings, and the brothers didn't die. But it lets you know about confession is kind of a wild thing, right? Even though they didn't kill him, they may have wanted to kill him, and so they went through this meeting their maker. There's another interesting piece to this idea of you can't compel somebody to be a witness against themselves. So at the same time that in the same Constitution, right, the amendments are after this has been written, there is a section which is known as the Fugitive Slave Clause. Does somebody want to read this? Hannah, can I put you on the spot with the mic? Oh, Charlie's going to do it. Okay.
Article 4, Section 2. No person held to service or labor in one state, escaping into another, shall be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due.
Yeah. That means that if you are a free black person in a state, in a free state, and you are assumed to be a fugitive slave, there is no due process.
So they could just say since you're black, you must be a slave, therefore.
Since you're black, you must be a slave, there is no due process. So at the same time that we have a strong claim for liberty, that you cannot take somebody's liberty or life away without due process, so that's in the Fifth Amendment, embedded right there in the Constitution itself is this other. So we have a little bit of a double standard perhaps in the United States. I don't mean to shock you all, but there is a double standard because it turns out due process does not pertain to everybody. And so there is a group of people who may be above the law, in which case that's not so great for our whole Republican form of government. So, but I wanted to put that in as part of our mix. We have a strong desire for these Fifth Amendment protections, and we've undermined it to some extent by saying that one class of people don't deserve due process. Okay, so that's all the historical piece. Just like Jinsey said earlier, the idea of the Fifth Amendment not compelling someone to be a witness against oneself is something the justices start to wrestle with. In 1954, this is not an actual Supreme Court decision. This is just Abe Fortas, who is a Supreme Court justice, writing in the Cleveland Bar Association Journal. Somebody want to read this? Jinsey, we'll give Jinsey that.
Mea culpa belongs to a man and his God. It is a plea that cannot be exacted from free men by human authority.
Yeah, so maybe the brothers wanted to confess to God that they always wanted to kill that nasty brother-in-law, but that should never be something that happens in a court of law. You can have strong psychological compulsions. You may have this death wish even. I mean, that's part of the issues with confession. Why are you confessing? And Abe Fortas starts to say, this is no business of the state. This is between you and God. Should never become part of evidence. In 1961, Felix Frankfurter, and this, when we start to get into the cases, they're usually pretty brutal murders. I mean, it's always a confession comes up and somebody's been brutally murdered. There's a lot of blood. It's a mess. But this idea of even though a terrible, brutal murder happened, that doesn't mean you get to compel confession is the thing that we have to hold in our heads at the same time, which is very difficult. Felix Frankfurter begins to ask questions about what constitutes forced confession or regular confession. Is the confession the product of an essentially free and unconstrained choice by its maker? If it is, he has will to confess and it may be used against him. If it is not, if his will has been overborne and his capacity for self-determination critically impaired, the use of confession offends due process. I just pulled out a few quotes. It's a 67-page treatise that Felix Frankfurter wrote, and he doesn't actually come down one side or the other. He just raises these issues. Did the person feel compelled? Was their will overborne? Was anyone feeling like their will has been overborne? When I say, Robert, now you should speak. You should be the next person to speak. Is that me coercing Robert, forcing him, will overborne? You can see how it's all like very psychological. And so Felix Frankfurter starts to raise lots of questions about it. So what does an overborne will look like in terms of the criminal justice system? Is that overborne will? Nobody's getting beaten up. Nobody's getting forced to do anything. He might have a threat. I mean, he's just sitting there. They're waiting for him to confess.
Wife or somebody or some other member of his family will suffer.
Fear for his wife or whatever. Is this overborne will? There is a handcuff on. I don't know. Eventually, they come up with a way to solve the problem because it's very hard to figure out whether somebody's will has been overborne. Anybody know how the Supreme Court solved the problem of forced confessions? It's a lovely, simple solution, and it's great for a certain industry.
Polygraph?
What?
Polygraph?
The polygraph? Well, I mean, you could think of that. In fact, it's a lawyer. How do you figure out whether somebody's will was overborne? Was there a lawyer with them or not? And this is the big decision, the Miranda decision. So Earl Warren says, the presence of an attorney enables the defendant otherwise compelling circumstances to tell his story without fear. You get a lawyer in the room, you are assumed to not be afraid. That's all it takes. Which is why we now have this. The Miranda Warnings, right? Everybody probably could recite this. As long as you have a lawyer in the room, you should be great. Eric, do you want to read the Miranda? Okay.
Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Waiver. Do you understand each of these rights? I have explained to you. Having these rights in mind, do you wish to talk to us now?
So it turns out you don't necessarily have to have a lawyer in the room. You just have to have the availability of a lawyer in the room. And if you don't lawyer up, but they've given you your Miranda warnings, then your will has not been overborne. And that's how we've solved this problem. Make sure you have a lawyer in the room, then you should be just fine. But even though this took place in 1967, clearly that's not the way it's always working, right? I mean, there's going to be, there's people in the room who maybe can talk about how, wow, they didn't do a Miranda right on that one. How did this go down? If you've seen Betty, yeah. Can we get her a mic?
How do you reconcile this with the fact...
Thanks.
How do you reconcile this with the fact that if you don't answer questions to federal officials, FBI investigators, to Congress, and so on, you're guilty? How is this reconciled? Even though you're not guilty, you're not testifying against yourself, but if you don't answer certain questions, they put you in jail.
And we should probably get some more specifics because that is a fairly broad generalization.
That's a federal law that if you lie to Congress or you don't answer questions to Congress or federal investigators, the FBI, CIA, and so on.
So Robert wants to jump in on this. Can we give Robert the mic? Let's pass it back.
That's okay. I just wonder, well, then why does Hillary Clinton, when she's called before Congress, exercise her Fifth Amendment rights?
Yeah, I mean, people...
She's not thrown in jail.
Right, people are using their Fifth Amendment rights all the time and not getting thrown in jail. We do want to clarify that, yeah. But this is a key piece that we understand that you may use the Fifth, and depending on where you're at, the public may think, oh my gosh, you must be guilty because you took the Fifth. But this is absolutely your right. Okay, just to move ahead, I wanted to bring this because maybe some of you have seen When They See Us, Ava DuVernay's 4-part Netflix series, which is about the case of the 5 young men Nowadays, they used to call it the Central Park Five. The term now is the exonerated five, because they were all exonerated. But what she does in this film is she shows how young kids are harassed until they confess. There are no lawyers present in those interrogation rooms because the parents fulfill that duty. But the parents are trying to get their kids out of the room, and the prosecutors are saying, if you confess, we'll let them go home tonight. And the whole thing just plays out, and you can see the psychology. What does compulsion look like? Is the fact, why aren't they getting a lawyer? Here they are kids. Well, because you have the parent. The parent is in the room. The parent doesn't ask for a lawyer. The parent can't afford a lawyer. And you begin to see the total miscarriage of justice. That's another picture of, is that an overborne will? Pretty clearly overborne will right there. So just the fact that we have our Miranda Warnings. So Betty's larger question of, even though we have a Fifth Amendment, why are certain people going to jail? This is an example of that. But going back to Miranda, it's not as if everybody, the decision was, the way we don't overbear somebody's will is we get a lawyer in the room. But Byron White said, wait a minute, we've gone way too far. It is by no means certain that the process of confessing is injurious to the accused. It may provide psychological relief and enhance the prospects for rehabilitation. That makes sense, right? I mean, a lot of times people confess and they feel a lot better. So maybe they went too far in Miranda. This was a dissent. They didn't get enough votes on this side, so it's not the law of the land. But it's a pretty reasonable argument, especially given the public expectations of confession. It's part of the idea that as your recovery, that confession is good for the soul. Step 1, admitting we're powerless. Step 4, make a searching and fearless written moral inventory of yourself. So there is an element in our culture, and I don't think this is a bad element, in which confession is understood to be rehabilitative. Rehabilitative? Sorry. And I just can't help but mention, I was just over at Probation and Parole, and they have a list of our 12-step meetings. And it says AA meetings, District 8. District 8 is our district for probation and parole. So there's an element where criminal justice system, the accused, and encouraging people to confess are getting awfully blurry. Yeah, Sheldon.
They're lawyers, and they're lawyers. And we need to recognize not all lawyers are equal.
Sheldon, what makes you say that?
All the cases in the South on civil rights where people are provided with lawyers, and those lawyers represent the local prejudices.
Yeah, exactly. So you may have a lawyer in the room and your will still be overborne. Your Fifth Amendment rights will be violated. This gets to, Daniel, yeah.
I think that's also true with these steps where this fundamentalist religion is given some credence in the legal process.
You're calling this a fundamentalist religion.
Fundamentalist religion.
This is very entwined with the legal process now.
It is.
Yeah.
And it's
And for people who are using the 12 steps faithfully, they're not happy with this situation because it takes what they were doing and all of a sudden there's a lot, it can be a condition of release or it can be mandated in some way. So they've lost their autonomy.
Right, and also then people are coerced into a religious practice in order to regain legal status of a particular faith. So it's just, if they're sending them to the Church of Satan, there'd be a public outcry, but these fundamentalists are buddy-buddy.
Yeah, and you're making this claim about fundamentalism. I guess I personally would not make that claim, but I am wanting to say that there are increased public expectations that confession is an important part of somebody's recovery, and it has gotten tied into the criminal justice system. To keep going, so this then brings us to this larger question, which is also in the Fifth Amendment about no person shall be deprived of life, liberty, or property without due process of law. Clearly, due process of law means your will should not be overborne, but it also means all the reasons that we said earlier. Fair, should not, Sheldon said there's going to be some lawyers who will respond to the local prejudices of the place. That's not fair. So that's a problem in terms of due process. Impartial, somebody used that term, that you want to have a neutral judge who's making the decision. It should be open. Most court cases, unless it involves children, should be open. You should be able to go in and see what's happening. It should allow for witnesses. All the things the Star Chamber did not allow for. It should maintain records. You should be able to face one's accusers, which is key. This is, again, public expectations. We don't have time to go in this tonight, but in terms of social media and to some degree the Me Too movement, when it just stays on social media, not when it becomes an actual case, people are accused and nobody has a chance to face their accusers. So this is one of those places where a really key practice is starting to erode in not a court of law, but on social media. Is there anything else that we don't have, that we missed? I'm not looking, I'm not fishing, but it's just to make sure. Is there something else that you feel like this idea of due process of law should also account for?
Legal representation?
Legal representation. And that really should be a good legal representation, absolutely.
That's money.
Yeah, right.
Appeal?
An appeal, yes, right. So now we're going to get down where it's a little harder. We've been able to sort of see what are these rights, how they came about, what was the historical circumstances, what are some of the vague terms, such as due process of law. But now I think we have a better understanding of what these rights are. But here's where it costs. I don't know. I hope you'll stay with me to the end. But this is where the what do they say? The rubber hits the road. Okay, so the cost of due process. William Blackstone said, he's another one of those legal thinkers, not an actual judge, he's a legal philosopher. He writes it down on a piece of paper and all of a sudden, whoa, it's almost as good as a judge. Better that 10 guilty persons escape than one innocent person suffer. That's the kind of due process you should get. 10 guilty people should escape because that's better than one innocent person suffers. And then Benjamin Franklin, who always likes to up the ante, you could always count on him. Like, if you say 1 in 10, I'm going to say 1 in 100. Better 100 guilty persons should escape than one innocent person should suffer. That's a big claim. They were really wanting to show everybody, we are not the Star Chamber. We are not doing that kind of thing. We are much happier to let criminals run around on our streets than to think anybody is spending time behind bars because a jury convicted them. We would much rather take that cost. That's quite an idea. Do you think we feel that way now in the United States? I see some shaking of heads. Yeah, doesn't that hurt? But this is what the cost is. This is how they understood it worked. You're going to have rights for the accused. That means the system is going to be set up with the presumption of innocence, heavy burden on the state, which means it isn't going to work, people, because we know how human beings are. They mess up most of the time. And we're going to live with those mess ups, because we'd rather have the mess ups than this other possibility that we'd have. Okay, but the Cato Institute is a fine institute, right? Libertarian. They do a lot of good surveys to find out what is the level of civil rights in the United States. They didn't do the 1 in 10. They didn't even want to risk that. Can you imagine trying the 1 in 10 ratio on the streets today? What are you, crazy? What kind of cost-benefit analysis are you engaged in? So they did 1-to-1. Is it worse? So they changed the syntax. Is it worse to let 20,000 guilty go free? 20,000 guilty go free, or to imprison 20,000 innocent people? So what do you think Americans said?
Lock her up.
Lock her up. 2016 they said lock her up. Yeah. That sort of suggests something, doesn't it? 60% said 20,000 innocent imprisoned is worse. 40%, 20,000 guilty people free is worse. And that figure is not just white people versus black people. They looked at all the demographics. Those figures hold consistent across white survey takers, black survey takers, Latino survey takers. Jinsey.
Well, it just seems to me that if you let the guilty go free, some of them might commit another crime and you catch them the second time. But if you imprison innocent people, there's nothing, you can't ever change that.
So did anyone hear what Jinsey just said? If you let the guilty free, chances are good, if they're a repeat offender, they're gonna mess up and do it again, and the next time you'll catch them. But if you put somebody in jail who's innocent, it's very hard to get them out. So,
Even to get over the experience.
or to get over the experience. And this is where I really highly recommend the Ava DuVernay's 4-part series, When They See Us, because it talks about what happens to these young kids and when they get out and how they try and put their lives back together.
Couldn't the inverse argument be made there, where if you let those 20,000 guilty free, they're going to commit more crimes, do more bad things, so the ultimate effect on society is worse? Whereas you lock up 20,000 innocent people, well, at least you know for sure they're not out doing more crimes, right? So it's crime prevention.
Are you trying to be provocative now?
No, I'm just flipping. I'm not saying it's what I think. I'm just saying it's another argument.
Yeah, so, and I appreciate, Daniel, you like trying to figure out, so how are we gonna make sense of this? Because 40%, that's a big part of the population. And those are 40%, they must have good reasons.
For the greater good,
For the
right?
greater good, yeah.
Make
All
some
right.
sacrifices.
Yeah, Gemma and then Jinsey. Oh, I got Eric first. But first Gemma.
Except for the fact that locking up 20,000 innocent people is committing 20,000 crimes.
Thank you. So locking up 20,000 people is committing 20,000 crimes. And for the state of New York, it was a $40 million settlement for these 5 young men. Eric, you wanted to say something. Can we get a mic to Eric? Oh, here, Eric has a mic. Oh, there's mics all over the place.
I think the way that we're defining guilty, and I think the way we understand, like, at what point do you let somebody free, like.
Do you want to tell them what you were just doing in Los Angeles, just briefly?
Well, I was working for an innocence project out in Los Angeles.
Mm-hmm. Trying
guess,
to establish innocence for people who had been in prison.
Yes.
Falsely in prison.
Yes. Yeah. I just think the way that guilty is defined, and I think the way we understand people who commit certain offenses, like I think a percentage of people who go to prison are not going to like just go out and start committing multiple, because somebody's gone to prison for burglary and they've sat in prison for 20 or 30 years, they're not going to go out and commit dozens of more burglaries just because they've been let free. Like, there are certain offenses that we understand there's an age at which people age out of crime. We understand that there are certain crimes, the recidivism rate is it's relatively small. Like, I just think putting in context is helpful.
And I appreciate what you're sharing with us, Eric, about even if somebody was correctly imprisoned, that doesn't mean that they should be in as long as they are, which is a slightly different thing than this. This is really getting to, if you were to have 20,000 people who were wrongly convicted in prison, is that worse than to have 20,000 people who are guilty running free? And that's all that was in front of these survey participants. And so 40% say it's much better to have the guilty, it is much worse to have the guilty free. So I want to keep, I got 2 hands up. Yes, so Hema?
Can I ask a quick question?
Yeah.
Why did they choose the number 20,000? Because if the question was asked, say 5, that has a different effect on the person being asked.
Right. So why did they go for 20,000? I don't know. But you're absolutely right. It's a very different idea. It's like masses of people incorrectly incarcerated. Masses of people who are guilty running free. And then what does that do to the brain? Do I really want masses of guilty people running free? Very frightening. Jinsey, and then I'm gonna,
Well, I think that if you imprison innocent people, they're going to suffer no matter what. They're all going to suffer. Some of those 20,000 people might think, oh my God, I got away with it. I'm not going to try that one again.
so the 20,000,
Guilty ones might not go out. I mean, it might scare them enough that they wouldn't go out, you know, and think, well, I got away with it, I think I'm going to quit now. But there's nothing that you can do to help the 20,000 innocent.
so Jinsey is saying that if you've gone through the judicial process and you got off, you're going to be chastened. You might be chastened. But again, this whole thing about imprisoning innocent people, you're never going to make that better. And I'll, you know, Gemma said, it's a crime. What are we going to do about that? So there is a strong argument out there for why, when somebody perhaps conducted a criminal act, why they should not have civil liberties. And this is around the Central Park case. There was a full-page ad put in 4 New York papers.
By
Somebody you might know.
Yeah, by...
And the title is Bring Back the Death Penalty, Bring Back Our Police. And I wanted to bring this to our attention because this is where you get the argument that, Daniel, you wanted to make. And I appreciate, Daniel, you were trying to understand what that argument is for the 40%, that it's worse to have guilty people running free. And I think a lot of people actually believe in this argument. How can our great society tolerate the continued brutalization of its citizens by crazed misfits? Criminals must be told that their civil liberties end when attack on our safety begins. And at the time in New York City, in 1989, people were feeling pretty freaked out. And it wasn't just the person who made this ad. High officials, normal people, women who jogged in Central Park. Everybody was feeling like the city had gotten totally crazy. Everything was out of hand. And this was the argument that was made. And it was very, very compelling to a lot of people. And Donald Trump, just so we all know. What is actually wrong with that argument? Just on a logical.
It doesn't, you don't know that the person is guilty.
Wow, you must have studied your civil liberties, Jinsey. Yes.
Know that the person is guilty.
You can't say criminal if somebody has gone through the judicial process. That's it.
Powerful mentally to read that.
Yeah, so Adam is saying it's powerful to read that. And why is it powerful?
Because you don't have to do a lot of the mental legwork to kind of do that, expend that extra effort in your mind to kind of say, oh, well, what if this person's not guilty? It's kind of already said right there. They're already identified as criminals. They're already labeled as such.
Yeah.
And it's already, you know, it's phrased in a way where it's not a question, the act, right? It's an attack.
Yeah, you don't have to think. You save so much mental labor. You just get to find out, okay, criminals don't have civil liberties. End of story. I don't even have to worry about this anymore. And crazed misfits, they don't have civil liberties anymore. Now, we can't...
Objection, Your Honor. That's prejudicial to my client.
Say more. That would be the response.
Yeah.
Yeah, and I would hope that we wouldn't say that the person who wrote that was a crazed misfit, because that would be engaging in that same exact logic, right? There would need to be some sort of trial. Yeah. Daniel.
Doesn't this also now brush up against the Second Amendment? The same person says, take the guns first, ask questions later. When there was mass shooting and they said the guy was crazy, he said, if the person's crazy, take the guns first, ask questions later, which could be seen as a direct violation of the Second Amendment.
So what is, and you're getting at maybe some of
these... It's the same thinking, right?
So I want to make sure, so you can say a red flag law, is that, I want to get us specifically into the law.
Right.
Is a red flag law similar in that it's taking away somebody's Second Amendment without actual formal hearing?
Right, without due process.
Yeah, and there's no due process, right. But okay. Does anybody know what the response is to that? I mean, because people have things taken away all the time. You get a restraining order on somebody, and some things are taken away. Is there no due process in restraining orders or red flag laws? There's a judge involved, exactly. And usually it's a temporary restraining order, and then you have to go back to the judge. So So that's different than taking a whole class of people and just calling them criminals. Although we have to be careful about red flag laws if it turns into there's a class of people and they just become all of a sudden misfits. Yeah, crazed misfits. Or mentally ill. Or, and I'm cautious when I hear terms like domestic terrorism, because it is going to be a term that will be used in order to take away rights. Because you'll get a nice broad ability to do that. So again, it's a cost, right? The cost of all this. I only have a few questions left, and we're going to open it up to a broad conversation. Do you all think the lawyer is going to be enough? Because that's what we have to protect our due process.
It might depend on the lawyer.
It's going to depend on the lawyer. That's what Sheldon's saying. But that's what we're really leaning on right now, to make sure that no will is overborne, is the presence of a lawyer. Anybody want to jump in on that one? Why?
Maybe 2 lawyers.
What? Maybe you need 2 lawyers. Better to have 3 lawyers than, well, I don't know.
Are these lawyers?
Yeah, Ellen. Ellen wants to say something.
Michelle Alexander.
Oh, sorry. Yeah.
Michelle Alexander in the mass incarceration book.
The new Jim Crow.
Jim Crow points out that lawyers, well-meaning liberals, have been distracted by the legal process of providing legal help when racism has, as exemplified by, well, as started by the original Fugitive Slave Act.
Right.
And that was great to put that in there, because that's really the background, which where, you know, the chickens are coming home to roost again, but you don't even have to say black. You just, you can say crazy misfits. So that's, yeah.
Yeah.
That's
So
the unspoken, that's, what do we need to bring that about?
So a lawyer may work for somebody who has a certain disposition, skin color, whatever, but even a lawyer may not be able to help people. They eventually did get lawyers, the Central Park, the young kids brought in under the Central Park case. Didn't help them. So there's even places where the confessions were held, they just were sent, they were hung up on their own words, and it was the confessions that made each one of them end up in jail. And if they hadn't thought so badly of those 5 young men, if somebody had been able to see, wait a minute, these kids have just got set up, it might have stopped. So the lawyer didn't help. So I'm curious, I was looking for some, like, what are these arguments that you have in favor of due process and against forced confessions? Do we have some that we can say, like, to Donald Trump? You can't know that forced confession is true, so there's an argument. Are we willing to make an argument right now that it's better for one innocent, it's worse? I have to say Blackstone's way. It is better for 10 guilty persons to escape than 1 innocent person to suffer. Can we still make that argument today? Is anybody making that argument? Like, really, that we can just let people not be put in jail because we assume the system won't work.
If they're bad, they're going to get caught later.
Jinsey's got that they're bad, they'll get caught later. Does anybody else have any other arguments? So let me take it down a level. So are you able to make a case for a terrible crime has happened in Vermont, and everybody thinks they know who did it, and that you could make arguments on the street on behalf of the defendant that the law may convict, the law may not convict. And if the law does not convict, I'm okay with that.
Maybe as long as you give some sort of concessions to the harmed.
To the harmed.
A lot of I think, I mean, I'm obviously speculating here, but I think a lot of times in cases of of justice, right? People ask what justice is. You've asked that in your classes. What is justice? A lot of people think that it's reprimandation from the perpetrators, right? Or it's like something bad happens to them, they go to jail, they get hung, whatever. I think as long as something good happens to the victim, then maybe there'll be a little more restorative.
Huh. So Adam is thinking that if we can come up with something so that after a horrible crime, there's a lot of attention given to the victim, something to make the victim feel whole, which is a little harder to do when these are pretty violent crimes. And there's a real strong notion of this person should suffer. And yet, given the system we have to say, maybe they'll suffer and maybe they won't. This person that we think did the crime. Maybe they'll get off free and maybe they won't. And if they get off free, that's okay. That's the cost of liberty. That's the kind of argument we have to make. I'm going to just keep pushing through a little bit more. And because the hard part is when the crime becomes very heinous. And certainly we've had really bad crimes around here. And people have died. And horrible things have happened to young children in this state. Sometimes they get into the news and sometimes they don't. And are we willing to still say, our system is the kind of system that maybe they get convicted and maybe they don't. And if they don't get convicted, this means our system is better. And then the last one is, how do we reckon with the crime of slavery? Because just as I think Gemma said, there was 20,000 crimes when innocent people were put in jail, we have a history of crimes that were never addressed, where due process was not recognized. Yes?
There came out a story about one of Nancy's girls that were involved in the murders, and she was never convicted. And after many, I'm guessing it was 20 years or so, where she was very depressed, and she and her therapist came to the decision that she had to commit herself and confess in order to live.
Right.
To stay alive.
Yeah, and that feels so important because that adds a whole other level to this. That so she had that right, but maybe the right didn't help her.
Right. So it was better to save innocent people to be convicted, because eventually most consciences will come around. And then it's not with separation of church and state, but personally I always go to St. Paul's advice to set a good example. And when you're forgiving and loving to someone who's really screwed up, they'll start to love themselves and behave better.
Yeah, right, exactly.
And that goes along with the 12-step philosophy.
Exactly. I mean, I think confession can be this very powerful, transformative method.
But it comes from within rather than from outside.
Ah, so then compelled. That's that piece of the Fifth Amendment that may in some ways be the most important part. That it shouldn't be compelled, but we don't want to stop it, because it can be quite restorative. Yeah. Other hands, yes, Sheldon.
We haven't recognized the period when taking the Fifth was so much part of our society. That was in the late 1940s and through the 1950s. It's known as the McCarthy period. But many people took the Fifth to avoid incriminating themselves. But the consequence was that they were seen as guilty, and they lost their jobs, and many had to go and live and work abroad. It was a difficult time.
And Sheldon's point about there are the consequences of maybe you don't get convicted, but then there's the public expectations. And if the public expectations are, you took the Fifth, therefore you must be an enemy of the United States, which is how it would have been framed under McCarthyism, then you may have a clean record, but you can't maintain yourself. Yeah. Yeah, so the Fifth Amendment, I said it was an inconvenient right. I think it's a really tough right. I think it asks a lot of us. And because it's 9/11, I just thought I'd end with one short quotation from John Dewey, because one theory is, why are we getting this way? Why do we now say 20,000 people, when we are doing that balance sheet, 40% of the population says it is worse for guilty people to go free? And one theory is because we are in a state of endless war. John Dewey said, War compels all nations, even the most democratic, to turn authoritarian. And if there's one piece where you can begin to understand the difference between an authoritarian system and a democratic system, it is under how are we understanding the rights of the accused. If we do not take the rights of the accused at all seriously, because who wants to have guilty people running in our midst, then we are actually acting for more of an authoritarian regime. And if we decide we want to have a democratic regime, then that's a big cost. We have to live amongst people who may be guilty and got off. But that's kind of what the Fifth Amendment is asking of us, I think. So thank you very much for coming out.